minute. Like I say, let's have a look at this here, and just read some of the things that they say in it. So, Idaho judge denies Bryan Kohberger's hollow attempt to strike death penalty. This is the 13th time the judge has ruled against the defence's attempt to remove the death penalty. Has there really been that many times? Has there been that many? 13 attempts to remove the death penalty? That's a bit mental, isn't it? I didn't realise there'd been 13 attempts. But look, an Idaho judge struck down with furious anger another attempt by Bryan Kohberger's defence to remove the death penalty from the table if he is convicted in the 2022 slayings of 4 University of Idaho students. Kohberger's defence team tried to strike the death penalty in a recent hearing, arguing the discovery produced by the prosecution had been large in volume and unorganised, meaning they were unable to meaningfully review it. Judge Stephen Hippler said the defense claims ring hollow. In other words, he basically told them to piss off. But look at what happened in the Lori Vallow case. Do you know what I mean? Was it too dissimilar to that situation? And she got hers fucking struck. Would Bryan Kohberger, would this have gone a different way if Bryan Kohberger would have been female? Do you know what I mean? I hate bringing that sort of shit up. Do you know what I mean? But that's the reality of it. Look at what happened in the Lori Vallow situation, and there you go. Is there reasonable doubt? Me, Panji? Yeah, I believe there is reasonable doubt, and we will come back to that. So, Kohberger's defense team tried to strike the death penalty ring hollow. Kohberger has been receiving discovery in the same manner for over 2 years, Hippler wrote. Kohberger has not sought additional resources to hire additional staff to review discovery or obtain litigation document control software to help organise and sort the evidence. His lead counsel insisted that she be allowed to take on a second high-profile capital case. See, this here, I find this problematic. If she actively went out of her way to try and get a hold of a second high-profile capital case, and then you're moaning about this and not being able to deal with discovery when you've said you want to personally check discovery, then that's idiocy. That is complete and utter idiocy. She hasn't got a leg to stand on, and Hippler was well in his rights to say, "Are you taking the piss?" Do you know what I mean? And that's coming from me. And you know what my stance is. I do want to see more. I'm supportive of Ann Taylor, but that is fucking stupidity. Well, how did she think that was going to go? If she's got time to take on a second high-profile capital case, then you've got time to look at this documents. Do you know what I mean? Who knows? We'll talk about the Steve G stuff and that as well towards the end. Hippler also pointed out that Kohberger's lead defense attorney, Ann Taylor, indicated that her practice is to personally review all discovery herself rather than rely on associates and staff to review materials and cut through the less relevant information and point out what materials need to be reviewed by lead counsel. Kohberger's attorneys had also filed a motion asking the judge to sanction prosecutors for failure to turn over evidence by removing the death penalty. But Hippler denied the request Tuesday and said the sanctions are not warranted because there was no violation by prosecutors in the discovery process. In the cases cited by defendant, where the courts have struck the death penalty as a sentencing option, defendant had demonstrated that the prosecution either willfully or inadvertently, but with extreme resultant prejudice, violated discovery obligations. Here, however, defendant has not established discovery violation, Hippler wrote. Well, no, because Ann Taylor's probably fucked that up. Do you know what I mean? Who knows? This is the 13th time the judge has ruled against the defence's attempt to remove the death penalty, the Idaho Statesman reported. Just last week, Hippler denied a separate effort for Kohberger's defense, which cited Kohberger's autism spectrum disorder diagnosis. His team argued that executing someone with autism would constitute cruel and unusual punishment under the 8th Amendment to the U.S. Constitution. Mr. Kohberger's ASD reduces his culpability, negates the retributive and deterrent purposes of capital punishment, and exposes him to the unacceptable risk that he will be wrongfully convicted and sentenced to death, defense attorneys wrote in court papers. There is an element of this which is true, because this is all about whether they make it very clear that he does have ASD. Because we've seen right from the start that it would seem that there was people around Bryan that looked at some of the things he did, some of his sort of his oddity, his behaviors, and misconstrued them as him being a weirdo, when in fact it could be attributed to ASD. So if he's sitting in court and people are looking at Bryan Kohberger, you've got all the jurors looking at him, or he reacts funny to something, or he's sitting funny, or they hear that, they get a witness in that says that he's fucking strange. It's you know what I mean? They need to make this ASD situation clear. But with respect of if he is guilty of the crime, if he is absolutely guilty of the crime, does he deserve to have the punishment? Then I don't think ASD should be a factor in it. Not unless they could prove beyond a reasonable doubt that the ASD was causation. I don't know. What's that? I'm not with you. No, AT knows exactly what she's doing. I'm not saying she doesn't know what she's doing, Susie. I'm saying that what she's doing here is she's saying that she's not ready for this trial, while simultaneously saying that she wants to take on another case. So I would argue with you there that if she's saying she knows what she doesn't know what she's doing. If she's trying to tell the judge that she hasn't got time to deal with Bryan's case when she's trying to actively take on another case, that's ridiculous. In the overarching, then I believe that she's a good attorney. She's doing a lot of things that she's doing it right. I think that she absolutely knows what she's doing. She's very good. The issue is here, that specific argument to say that she's not. We all heard her say that she wasn't prepared. Okay, you're fair enough. You're saying you weren't prepared. Well, why are you trying to get another fucking case then? Another high-profile capital case. It's, you need somebody who is 100. Bryan needs someone who's 100% in his corner. Absolutely on it, bang, all the attention, everything. You know what I mean? There we go. So what do we got? Prosecutors argue that under US Supreme Court precedent, the only mental disability that precludes imposition of the death penalty is an intellectual disability, and Kohberger's diagnosis was of mild autism without accompanying intellectual impairment, which we know he doesn't seemingly have intellectual impairment. His impairments are mainly towards social cues and small, like he'll stare, he plays with his hands a bit, things like that, the rigidity of his body, but there's nothing, his intellectual. Mind you could argue that. I would argue that, because you could turn around and say, well, you're saying that there's no intellectual impairment, but you're saying he's guilty of this crime, so that means that this dumb motherfucker drove his own car, took his phone, ordered everything off fucking Amazon to do this crime. Not being funny, but that is indicative of fucking intellectual impairment, because that makes him the stupidest motherfucker that's ever walked into a court for a mass murder. He drove his car around Moscow, Idaho, to get caught on every single camera around the property. And then, after he did the crime, he seemingly got on his phone and took a fucking selfie with his thumbs up. If he is proven to have done, then that is intellectual impairment, and he would have that picture would be in the dictionary, Bryan's selfie with intellectual impairment written next to it. So there is an argument there. I think I could probably get that swayed in court. Prosecutors argued that under US Supreme Court precedent, the only mental disability that precludes imposition of the death penalty is an intellectual disability. Oh, I'm reading the same fucking thing twice. That's my intellectual disability. I'm not even joking. To turn around and say that he's got no intellectual impairment, that would prove, if he's guilty of this crime, that he does have intellectual impairment, because he's stupid. Why is Ann Taylor fighting the state to not let them evaluate him? If she had him evaluated, they should be able to evaluate him for penalty phase. I don't know that. I don't know. It does seem a little bit odd that she is fighting it. Maybe because she thinks they could come back and get a biased report that diminishes the result that they got. I don't know, because he is mild, isn't he? So could somebody else with a more biased opinion try and rubbish that and put it down to someone else? I don't know. There's obviously some issue there. Maybe she just don't trust him. I don't know why that'd be. The judge ruled that prosecutors can pursue the death penalty against Kohberger if he's convicted, despite the defendant's recent autism diagnosis. Prosecutors have long said they intend to seek the death penalty if Kohberger is convicted of the brutal slayings. Kohberger, 30, is charged with the deaths of University of Idaho students Kaylee Gonsalves, Madison Mogans, Anna Knodel, and Ethan Chapin at an off-campus house in Moscow, Idaho, during the early morning hours of November 13th, 2022. Criminal justice graduate student who studied at Washington State University at the time of the killings was arrested in Pennsylvania weeks later. Check this out. So investigators said they matched his DNA to genetic material recovered from a knife sheath found at the crime scene. So this is always sat uncomfortable for me. So they didn't send the entire knife sheath off. They just extracted the knife, the genetic material from the knife sheath, and sent the extracted genetic material to the lab. Is how some of that reads. Like I think the very last sample that went to the FBI, for instance, it weren't the sheath that was sent; it was a sample that was sent. It's about trusting everyone, isn't it? It's about trusting law enforcement. It's about trusting all of the people around it, all of the cops, everyone who had their hands on it. Like, look at the Brent Kohberger situation. Do you not? There can't be anybody, surely, who doesn't sit slightly uncomfortable with what happened to Brent Kohberger? Surely not. There's got to be a lot of people in the community that looked at that Brent Kohberger situation that sits uncomfortable with them. Kohberger, Freudian slip. I'm like Judge John Judge. Kohberger's trial is expected to start with jury selection on July 30th and opening statements slated for August the 11th. Put that in your diaries, August 11th. But no, you'll have to, like I say, let me know how you feel about that. It's a bit mental. It is a bit mental. But that is the last of the docs. Weird one, isn't it? But I'm sure we're going to see a lot more in the upcoming days. Not upcoming days. What's that? Calm down, Harsh. We still love you. Not freeloaders. We're poor. It doesn't cost you to hit like. It's free. You can't say that that you're poor and you can't hit like. Mwah.